I would also tell you to try to cooperate. If there's no reason to resist arrest, to try to flee on foot, which is a misdemeanor, or flee in a vehicle, which is a felony. There's no reason to try to hide evidence that they're going to find or destroy evidence. That's tampering with evidence. That can be a felony. They're going to take you to jail if they're going to take you to jail. They're probably going to search you if they're going to search you. I would also tell you, don't try to be Matlock on the side of the road. Don't, even if you know your legal rights, all that does is upset the officers and inflame them trying to argue with them. You're not going to win your case or your trial on the side of the interstate or, at your front door. Leave that up to the attorney. Just be quiet, invoke Fifth Amendment right, ask for attorney. Now, once you're to the point of being arrested, they take you down to the jail. They're going to intake you into the jail. They're going to ask some basic questions. You need to cooperate with the judicial magistrate because that person decides whether or not you're going to get bond, and if so, how much it is. If you cooperate, and if you live locally, you don't have any prior record, and you're not a flight risk and those types of things, and it's not a real serious crime, they might ROR you, which means release you on your own recognizance for no money, or they might set a very low bond. Whatever your bond is, if you go through a bonding company, you're going to pay 10% of that plus $37. So let's say they set your bond at $5,000. You got to pay $537 to get out. If they set it at $10,000, got to pay $1,037 and so on. Cooperate with that person because they're the one that's going to set your bond. Now, once you make bond, you're going to be given your papers, the affidavit of complaint, your arrest warrant, your bonding papers, any special bond conditions. You need to pay attention to that because if you don't follow those, they can revoke your bond and put you back in. Then you need to call an attorney like myself, make an appointment as soon as you can, bring all that paperwork in. And when you bring that paperwork in and turn it over to us to review, the other thing that you're going to need to do is if you've got any witnesses that you think can help you, while your memory's fresh, write down their names, their addresses, their phone numbers, your relationship to them, how you know them, and what they know, what they have firsthand knowledge of. If there's any exhibits or proof that proves anything, like say you got stopped and one of the charges was failure to provide proof of insurance, automobile insurance. You just couldn't find your card that night, but you've got it. Bring me your card that was in effect at that time. If you couldn't produce a valid registration, but you found it later, bring that to me. If you couldn't find your driver's license or your license was expired, but you've gotten it renewed, bring that in. If you had a tail light out and you had that repaired since you were pulled over, bring me proof of that. Anything like that that you've cleared up, we can get a lot of those things dropped, either just dismissed out and out, or we can get it retired on payment of cost. But bring all that information to bear when you come in, and we will talk about everything and tell you whether or not we think we can settle this case in general sessions, which is generally smaller charges, misdemeanors. You can't settle or try a felony in general sessions court. Or if it's a felony, can we plead it down from a felony and keep it in general sessions court? Or if it's going to have to be bound over to the grand jury and sent up to criminal court, or if we're going to have a preliminary hearing to determine if it's going to be bound over.